The Labor Code of the Philippines, Article 125, Freedom to Bargain. No wage order shall be construed to prevent workers, in particular firms or enterprises or industries, from bargaining for higher wages with their respective employers. Article 126, Prohibition against injunction. No preliminary or permanent injunction or temporary restraining order may be issued by any court, tribunal, or other entity against any proceedings before the commissions or the regional boards. Article 127, Non-diminution of benefits. No wage order issued by any regional board shall provide for wage rates lower than the statutory minimum wage rates prescribed by Congress. Chapter 5, Administrative and Enforcement. Article 128, Visitorial and Enforcement Power. A Secretary of Labor and Employment or his duly authorized representatives, including labor regulations officer, shall have access to employers' records and premises at any time of the day or night whenever work is being undertaken therein, and the right to copy therefrom, to question any employee and investigate any fact, condition, or matter which may be necessary to determine violations or which may aid in the enforcement of this code and of any labor law, wage order, or rules and regulations issued pursuant thereto. B. Notwithstanding the provisions of Article 129 and 217 of this code to the contrary, and in cases where the relationship of employer-employee still exists, the Secretary of Labor and Employment or his duly authorized representative shall have the power to issue compliance orders to give effect to the labor standards provision of this code and other labor legislation based on the findings of labor, employment, and enforcement officers or industrial safety engineers made in the course of inspection. The Secretary or his duly authorized representatives shall issue writ of execution to the appropriate authority for the enforcement of their orders, except in cases where the employer contests the findings of the labor, employment, and enforcement officer and raises issues supported by the documentary proof which were not considered in the course of inspection. An order issued by the duly authorized representative of the Secretary of Labor and Employment under this article may be appealed to the latter. In case said order involves a monetary award, an appeal by the employer may be perfected only upon the posting of a cash or surety bond issued by a reputable bonding company duly accredited by the Secretary of Labor and Employment in the amount equivalent to the monetary award in the order appealed from. C. The Secretary of Labor and Employment may likewise order stoppage of work or suspension of operations of any unit or department of an establishment when non-compliance with the law or implementing rules and regulations poses grave and imminent danger to the health and safety of workers in the workplace. Within 24 hours, a hearing shall be conducted to determine whether an order for the stoppage of work or suspension of operations shall be lifted or not. In case the violation is attributable to the fault of the employer, he shall pay the employees their salaries and wages during the period of such stoppage of work or suspension of operation. D. It shall be unlawful for any person or entity to obstruct, impede, delay, or otherwise render ineffective the orders of the Secretary of Labor and Employment or his duly authorized representatives issued pursuant to the authority granted under this article, and no inferior court or entity shall issue temporary or permanent injunction or restraining order or otherwise assume jurisdiction over any case involving the enforcement orders issued in accordance with this article. E. Any government employee found guilty of violation of or abuse of authority under this article shall, after appropriate administrative investigation, be subject to summary dismissal from the service. F. The Secretary of Labor and Employment may, by appropriate regulations, require employers to keep and maintain such employment records as may be necessary in aid of his visitorial and enforcement powers under this code. Article 129, Recovery of wages, simple money claims, and other benefits. Upon complaint of any interested party, the regional director of the Department of Labor and Employment or any of the duly authorized hearing officers of the department is empowered through summary proceeding and after due notice to hear and decide any matter involving the recovery of wages and other monetary claims and benefits, including legal interests, owing to an employee or person employed in the domestic or household services or house helper under this code, arising from employer-employee relationship, provided that such complaint does not include a claim for reinstatement, provided further that the aggregate money claims of each employee or house helper does not exceed 5,000 pesos. The regional director or hearing officer shall decide or resolve the complaint within 30 calendar days from the date of the filing of the same. Any sum thus recovered on behalf of any employee or house helper pursuant to this article shall be held in a special deposit account by and shall be paid on order of the Secretary of Labor and Employment or the regional director directly to the employee or house helper concerned. Any sum any such sum not paid to the employee or house helper because he cannot be located after diligent and reasonable effort to locate him within a period of 3 years shall be held as a special fund for the Department of Labor and Employment to be used exclusively for the amelioration and benefits of workers. Any decision or resolution of the regional director or hearing officer pursuant to this provision may be appealed on the same grounds provided in Article 223 of this code within 5 calendar days from receipt of a copy of said decision or resolution to the National Labor Relations Commission, which shall resolve the appeal within 10 calendar days from the submission of the last pleading required or allowed under these rules. The Secretary of Labor and Employment or his duly authorized representative may supervise the payment of unpaid wages and other monetary claims and benefits, including legal interests, found owing to any employee or house helper under this code. Title 3, Working Conditions for Special Groups of Employees. Chapter 1, Employment of Women. Article 130, Facilities for Women. The Secretary of Labor and Employment shall establish standards that will ensure the safety and health of women employees. In appropriate cases, he shall, by regulations, require any employer to a. Provide seats proper for women and permit them to use such seats when they are free from work and during working hours, provided they can perform their duties in their position without detriment to efficiency. B. To establish separate toilet rooms and lavatories for men and women and provide at least a dressing room for women. C. To establish a nursery in a workplace for the benefit of the women employees therein. And D. To determine appropriate minimum age and other standards for retirement or termination in special occupations such as those of flight attendants and the like. Article 131 superseded by Social Security Act. Article 132 Family Planning Services, Incentives of Family Planning. A. Establishment which are required by law to maintain a clinic or infirmary shall provide free family planning services to their employees, which shall include but not limited to the application or use of contraceptive pills and intrauterine devices. B. In coordination with other agencies of the government engaged in the promotion of family planning, the Department of Labor and Employment shall develop and prescribe incentive bonus, SIM, to encourage family planning among female workers in any establishment or enterprise. Article 133. Discrimination prohibited. It shall be unlawful for any employer to discriminate against any woman employee with respect to the terms and conditions of employment solely on account of her sex. The following are acts of discrimination. A. Payment of a lesser compensation, including wage, salary, or other form of remuneration, and fringe benefit, to a female employee as against a male employee for work of equal value. And B. Favoring a male employee over a female employee with respect to promotion, training opportunities, studies, and scholarship grants solely on account of their sexes. Criminal liability for the willful commission of any unlawful acts as provided in this article or any violation of the rules and regulations issued pursuant to Section 2 hereof shall be penalized as provided in Article 288 and 289 of this Code, provided that the institution of any criminal action under this provision shall not bar the aggrieved employee from filing an entirely separate and distinct action for money claims, which may include claims for damages and other affirmative reliefs. The action hereby authorized shall proceed independently of each other. Article 134. Stipulation against marriage. It shall be unlawful for an employer to require as a condition of employment or continuation of employment that a woman employee shall not get married, or to stipulate expressly or tacitly that upon getting married, a woman employee shall be deemed resigned or separated, or to actually dismiss, discharge, discriminate, or otherwise prejudice a woman employee merely by reason of her marriage. Article 135. Prohibited acts. It shall be unlawful for any employer, 1. To deny any woman employee the benefits provided for in this chapter, or to discharge any woman employed by him for the purpose of preventing her from enjoying any of the benefits provided under this code. 2. To discharge such woman on account of her pregnancy or while on leave or in confinement due to her pregnancy. 3. To discharge or refuse the admission of such woman upon returning to her work for fear that she may again be pregnant. Article 136. Classification of certain women workers. Any woman who is permitted or suffered to work with or without compensation in any nightclub, cocktail lounge, massage clinic, bar, or similar establishment under the effective control or supervision of the employer for a substantial period of time, as determined by the Secretary of Labor and Employment, shall be considered as an employee of such establishment for the purposes of labor and social legislation. Chapter 2, Employment of Minors, Article 137. Minimum employable age. A. No child below 15 years of age shall be employed except when he works directly under the sole responsibility of his parents or guardian, or his employment does not in any way interfere with his schooling. B. Any person between 15 and 18 years of age may be employed for such number of hours and such period of the day as determined by the Secretary of Labor and Employment in appropriate regulation. C. The foregoing provisions shall in no case allow the employment of a person below 18 years of age in an undertaking which are hazardous or deleterious in nature as determined by the Secretary of Labor and Employment. Article 138. Provision against child discrimination. No employer shall discriminate against any person in respect to terms and conditions of employment on account of his age. Chapter 5. Employment of night workers. Article 154. Coverage. This chapter shall apply to all persons who shall be employed or permitted or suffered to work at night, except those employed in agriculture, stock racing, fishing, maritime transport, and inland navigation during a period of not less than 7 consecutive hours, including the interval from midnight to 5 o'clock in the morning, to be determined by the Secretary of Labor and Employment after consulting the workers' representative, labor organization, and employers. Night workers means any employed person whose work requires performance of a substantial number of hours of night work which exceed a specified limit. This limit shall be fixed by the Secretary of Labor and uh, employ and the Secretary of Labor after consulting the workers' representative, labor organization, and employees. Article 155, Health Assessment. At their request, workers shall have the right to undergo a health assessment without charge and to receive advice on how to reduce or avoid health problems associated with their work. Article 156, mandatory facilities. Suitable first aid facilities shall be made available for workers performing night work, including arrangement where such workers, where necessary, can be taken immediately to a place for appropriate treatment. The employers are likewise required to provide safe and healthful working conditions and adequate and reasonable facilities such as sleeping or resting quarters in the establishment and transportation from the work premises to the nearest point of their residence subject to exemption and guidelines to be provided by the DOLE. Article 157, Transfer. Night workers who are certified as unfit for night work due to health reasons shall be transferred whenever applicable to a similar job for which they are fit to work. If such transfer to a similar job is not practicable, these workers shall be granted the same benefit as other workers who are unable to work or to secure employment during such period. A night worker certified as temporarily unfit for night work shall be given the same protection against dismissal or notice of dismissal as other workers who are prevented from working for reasons of work. Article 158, Women Night Workers. Measures shall be taken to ensure that an alternative to night work is available to women workers who would otherwise be called upon to perform such work. A. Before and after childbirth for a period of at least 16 weeks, which shall be divided between the time before and after birth. B. For additional periods in respect of which a medical certificate is produced stating that said additional periods are necessary for the health of the mother and the child.